cut you off of clients that you do also want to serve. But certainly, I think it's just another way of kind of distinguishing yourself from the crowd.
That's very clever. That's good. No,
yeah,
I'm serious.
Thanks. Yeah.
Can you walk us through when you're meeting with a potential client as a consult, you just drop them the retainer bomb, and they're kind of looking at you with the funky eyes. And how do you segue into this LAR, and especially in a family law sense, you say, look, I can go straight and help you with the filing of the complaint, and then you go from there to break out different dates or potential court appearances. I mean, how do you do that?
I just move into it directly. I feel that the mantra is, it depends, but it depends what I've already told them, what they've needed to know. So for instance, if it is truly an initial consultation, they know very little about the divorce, and they're specifically asking, what do you do? What is the process? So I've taken them through the filing, what needs to be done in terms of filing, what will happen between then and, say, a potential trial, the pretrial, but then what may happen in the interim, because there's the possibility of temporary orders, which of course are not for everybody. What happens immediately upon service, the automatic restraining order, theoretically the exchange of 410 documents. And so if they have an idea already, then I can say some of these can be broken down.
I will kind of have my initial consultation, and then I'll move into the piece about the fees, and I'll have kind of given them the hairy eyeball, like, how much money do you really have in your bank account? Are they like telling me they're poor? Are they check to check? I give them a hairy eyeball, and if I think that they've got the money in the bank to write me a check, and if I think I've kind of created a value proposition for my services at that point where they'll write it, I'll skip the LAR. But if I think that maybe they're in a higher income bracket, but they're not quite ready to commit, and they still want a date, I'll bring it up. Or if oftentimes it's somebody with limited financial resources, they don't qualify for pro bono, but they can't write a big check, I just go straight into it. I just kind of present that as, this is how I do it, and this is what's great about it. This is what it entails.
My practice has changed a bit in the last few years. It used to be, or the last couple of years, it used to be, and I don't think this is a cocky statement, it used to be when somebody came in for a consultation with me, they retained me. In part because my referrals come as word of mouth, very specific, somebody they know knows me and they've referred them. So I don't do a lot of online, whatever those sites are called, social media. I don't even know that. I don't accept a lot of clients that way. I find my clients, I prefer the clients that I get through word of mouth, people who know me. And I don't even know exactly where I was going with this, I'm sorry. I'm sorry, I just lost my train of thought for a second. Why don't you go on? I'll get back to it in a second, I'm sure.
Yeah. Other questions? Or? Yeah.
Do either of you two work on the probate side?
I don't at all. No.
I don't at all. Yeah. I mean, I've done a guardianship, done very limited guardianship cases. Really, the case that you aren't supposed to take for a friend. The Rule 101 of, good practice. I have taken that case, but I don't think I would ever do. I mean, I wouldn't do it enough to do an LAR. But it's a great question, and I will say that I think guardianship cases are ripe for LAR. I think that a few attorneys really promoting themselves and getting the word out that they will do guardianships on an LAR basis will be brilliant and will have a very full practice, especially now. Filling out the forms, they're hard. I'm a reasonably smart person. They're hard to fill out for the average person who's already going through, a difficult time in their life. So, I would encourage anybody who does that side of the family and probate and family court to consider it. There is an attorney who's doing a great job of LAR, and I know she was looking to promote it, and I'd be happy to mention her name to you afterwards. I don't know if she'd want me to mention her name out loud. I don't know why, but.
I have a question about, you said in your engagement letter that you will do another engagement letter that goes to trial. So when you file your appearance in a case like that, that's still a general appearance?
I want to make sure I understand. I didn't say that I file, are you talking about in an LAR?
Well, you were saying that you will, in your engagement letter, you were saying that you will, there's a whole other agreement that you talk to the client about if it's a case that's going to go to trial.
I provide in my regular engagement letters a different retainer requirement for when it goes to trial. I don't do another engagement letter because my engagement letter has already addressed all these things. What it says is this is the retainer I want right now. But if it goes to trial, this is the retainer I'm going to need.
That's separate from LAR.
It's separate from LAR. Now, by definition, I think LAR, you would need a new engagement letter if you were going to take it to trial, unless, I don't see how you'd get around it. I mean, it would be brand new, because otherwise you would just file a general appearance if you were going to take it all the way through. And I think that would be, I've never done, just the trial in an LAR context. I don't see, you wouldn't need to, because it's going to end it. But I will say that if I were to file an appearance for a trial, having not already represented somebody all along, I think I would need to change that engagement, my regular engagement letter, to really make it clear right from the start about what it would entail to handle the trial and when it would end, because that's the big it ends at a particular time, which is the the judgment.
There was, yeah.
Not run amok, the IOPA rules and claim flat fees and hourly rates. The minute you file your appearance and your discharge, and you're done with that case, if there's any retainer left, you have to retain the remainder at that point. You fund the remainder at that point to the client, right?
Well, I'm hearing two different questions, because if it's a flat fee, I'm sorry?
Flat fee versus IOPA. Flat fee is easy, but if they gave you a retainer and you didn't eat all that up, fill all that up, and there's X amount of dollars left, you need to file your disengagement. It seems to me you'd have to fund that back to the client at that point. It's just a lot of extra cumbersome. Especially if you think they're going to retain you at another point in time. You just kind of have a hard time getting my hands on it.
Yeah, I mean, in the same way that I hopefully have some money left in my retainer after I conclude, a regular appearance engagement, I do my final billing and whatever follow-up is necessary, and then I send, with my disengagement letter, and maybe I'm getting confused. Disengagement letter is different than my notice of withdrawal. I mean, my notice of withdrawal is with the court, but I, as a matter of practice, do a disengagement letter or end of representation letter, and say, and happy day, here's your 39 cents back from all that. But I do it in the same fashion, and hopefully promptly. It depends. Now, I keep on saying that your representation ends when judgment enters, but many of us know that's not entirely so, because there's cleanup after a divorce. There's, still you're dividing the property or dividing the accounts. You're shepherding through the quadros. I don't do quadros myself, so, I'm making sure that they get done, whatever it may be. But yeah, it's in the same fashion that I give it back. And it's no more, no more of a hassle.
Yeah.
And then, for you have flat fees, so that's one less step.
Yeah, I'm like, checkbox, I got paid. Cool. Yeah. Was there another one in the back?
Have either of you taken on a relationship where you're just acting as a consultant? Like consultant or advising LAR?
Yeah, absolutely. I do that. I have definitely a stream of clients who they kind of call me on an as-needed basis. They'll often kind of have an initial consultation, and then they'll say, okay, thanks for the information. Let me go think on that. And then, maybe they'll go to an appearance the following week, and they'll come back in, and they'll give me, we'll have another meeting. And I mean, I always am just want to err on the side of communicating and over documenting. So I do a new kind of agreement letter, the whole thing every time, and that may or may not be necessary. But I find that for that, some clients, I've met them half a dozen times, and I've never gone to court. I've never spoken to opposing counsel. I've never even helped them fill anything out or done a pleading with them, but it's all kind of conversations. Well, what about this? What about that? This happened. You know, how should I handle this? And, you know, it's again just kind of memorializing and writing. You know, we spoke for this purpose, you know, generalized advice based on my understanding of the facts that you provided. So, yeah.
You've written that letter before, haven't you?
Yeah, yeah.
Yeah, and I don't think it's exclusive to LAR. You know, I think, and now again, with the new law, if it's going to be an ongoing consultation, you are required to have a written engagement letter. But I don't think it's necessarily LAR, although I think that LAR, the principles and some of the forms that they give you can help in how to address consulting sometimes, because they may say, you know, I don't want you to deal with anything financial. Well, you know, it's hard sometimes if you've not reviewed financial documents to really tell them what a fair, reasonable, or what they can expect in terms of a property division is. So to be clear on those accounts. And so it may be helpful to use the LAR forms of communicating with your client to say, okay, you're going to do that. You know, you're going to you know, value the marital home, or have the marital home valued.
And often too, you do have clients where, you know, somebody filed a modification and then there's a contempt and then there's something else, and they have kind of different dates that are on different tracks. So I might help them want the client with the modification but not be involved with the contempts. And again, it's just being extra clear with everyone involved about what you're in on and what you're not in on.
Any other questions?
I just wanted to highlight on the very last slide, there's a couple of resources. The first one is the Senior Partners for Justice and the Volunteer Lawyers Project. Those are the materials that you mostly received today. But there's two other websites that are also very helpful that I just wanted to point out. One is the ABA Standing Committee on the Delivery of Legal Services. They have a really good pro se unbundling resource center, and they actually compile resources from all of the different states that do LAR. So there's a Massachusetts link, but there's a Maine and an Indiana and an Illinois link, and they have forms and manuals and standing orders and articles and laws and all kinds of different materials that you can kind of read through at your leisure. And I'm always kind of, you come up with like different ideas, you know, you're like different ways of using it in your practice, different ways of kind of communicating about it, how to talk about it, how to describe it. So that's a really comprehensive website. And also the Massachusetts Trial Court Library has, that website has a lot of the links to the relevant Massachusetts statutes and standing orders and forms. It is also in the housing court, which I believe they're talking about, but it is in the district court and non-civil matters, the land court and the housing court. So there's different court departments have different standing orders, and it's good to be aware of what they are and the different requirements and rules.
Great advice. Well, congratulations on getting certified. I wish you all the best. I have found it enormously helpful in my practice, and I wish you the same. Have fun with it. You know, don't be too freaked out by it. It's really just practicing the same with, you know, a little bit. Oh, the one other practice tip that I do want to mention, I forgot to do. I'm sure in the books there's the limited notice of appearance and the notice of withdrawal. That's online as well in a PDF. I would strongly encourage you to use those. I've never had a problem one way or the other, really, but I just think it's easier for the clerk to see it and notice it's different. You know, you don't have to use those. You can use your own regular notice of appearance, but I really do think it's just helpful for the clerks to see it, and they're seeing it more and more now. And I also think it's helpful for opposing counsel, because most people, when you get a notice of appearance, I mean, you just throw it in the file with, other pleadings. You don't really look at it. It's not where you get the contact information. So there's really no reason for most of us, to really look at a notice of appearance. I think using their PDF highlights it.
Yeah.
So that's my little practice tip.
Cool.
Well, I'm sure in the program materials somewhere, well, certainly on this is Cynthia's contact information. I'm sure Cynthia would be welcome to get any phone calls.
Sure.
And I'm sure my information is around as well. Please do feel free to call at any time. I think this is great for practice, but I really, really believe in it as access to justice for the public. And that's why I promote LAR as much as I do. I have done the roadshow with Judge Ginsburg and other people who have really worked on promoting LAR in the courts. I just think it's a fabulous, fabulous thing. So congratulations for doing it. I think that your practices will thrive, I believe. But I think it's also a really great thing for pro se litigants. So have fun with it and have a great new year.
Oh, really? Yeah, for sure. Yeah, for sure. Oh, I think she just wanted to. Yeah, she'll be back. She's not going far. Oh, yeah. Hi.
This was great, thank you.
Oh, good. I'm glad it was helpful. No, I think we turned it off.
So I'm really just getting started.
Yeah, what's your name?
My own practice, Amy.
It's nice to meet you, Amy.
And actually, the family